This is Raiford Palmer of STG Divorce Law in Chicago, author of I Just Want This Done, How Smart, Successful People Get Divorced Without Losing Their Kids, Money, and Minds, fellow of the American Academy of Matrimonial Lawyers and long-term divorce attorney. Here to talk to you about prenuptial or premarital agreements. In Illinois, premarital agreements, also called prenups, are used as a contract between two people to determine what happens in the event they get divorced. These are governed by the Illinois Uniform Premarital Agreement Act, which the citation down in the notes below is 750 ILCS 10. There is no consideration needed for prenuptial agreements, meaning you don't have to give any special money or anything in exchange for getting the premarital agreement signed. It's enough that you're going to get married in exchange for the terms of the premarital agreement. The agreement is prepared and signed before marriage. A premarital agreement is not valid if it is signed after the marriage. And importantly, it has to be in writing and signed by both parties. A notary is not required. It doesn't have the same requirements, for example, as a will. It's important, as a little side note, to keep copies in a safe place, both electronic copies and some paper copies, keeping in a safe deposit box, or electronic copy in Dropbox or Google Drive, for example, a number of places, so you have multiple copies. We've had instances of clients contacting us, talking about the fact that they have a prenup, only to find out they can't find the prenup, and lo and behold, their soon-to-be ex has lost all the copies. So be safe. If you get a prenup, keep multiple copies in different places. A prenup is not a substitute for an estate plan. While a prenuptial agreement can determine what happens to certain property upon death, it is not the substitute for a valid will, trust, and powers of attorney in the state of Illinois. So always consult with a licensed and experienced Illinois estate planning attorney, and we're happy to provide references upon request for those attorneys so that you can get an estate plan prepared. Be sure you finalize your estate plan and sign everything after you get married, because the circumstances change after marriage, and an estate plan that you prepare before the marriage won't take care of you in the way that you need it to after you get married. You will want to wait until you get married to revise or create a new estate plan, because your rights vis-a-vis each other change upon marriage. So let's talk next about what you can resolve with a prenuptial agreement. First, and maybe obviously, you can resolve property rights in a prenuptial agreement. So for example, determining how marital property is created can be set forth in a premarital agreement. Also, designating property you had before the marriage as your non-marital or separate property can be done in a prenuptial agreement. You can also determine how you will buy, sell, rent, or mortgage property or borrow against property in a prenuptial agreement. You can also determine how property will be disposed of in the event of separation, divorce, death, or some other occurrence. Next, you can modify or eliminate spousal support. You can deviate from the Illinois law in terms of how spousal support is determined by setting forth a different plan or different scheme in your premarital agreement. For example, you could have a mutual waiver of support, meaning each person gives up any claim to maintenance. You could set forth a schedule for support or some limited period of time. You could have other conditions set forth regarding maintenance that are not provided by Illinois law. The premarital agreement terms can require the making of a will or trust to carry out the provisions of the agreement. You can also set forth the choice of state law that will apply to determine the outcome of the agreement. The premarital agreement can also deal with ownership rights and the apportionment of life insurance benefits in the event of divorce. And Illinois law allows you to determine any other matter not in violation of Illinois public policy. For example, you can predetermine how attorney's fees are allocated between the couple in the event of a divorce. For example, attorney's fees just paid by each person individually, or divided equally, or some other plan entirely. Illinois law might provide that you have to contribute to the other person's attorney's fees in part or in whole, depending on the circumstances. So you may want to get this confirmed in advance in the prenuptial agreement. Another provision you can find in Illinois premarital agreement is one controlling and determining the payment for health insurance and medical expenses between the couple in the event of divorce or separation. Here's a list of things that you can't resolve in a premarital agreement. Number one, child custody. Issues of child custody, including parenting responsibilities and visitation, can't be determined by a prenuptial agreement. Next, child support. Child support issues cannot be determined in a premarital agreement. Then, payment of other expenses for children, like child support, cannot be determined in a prenuptial agreement. Also, the parties cannot determine in advance the payment of college expenses for children. So essentially, all things related to children really can't be determined in a prenuptial agreement. That's because the court has to approve those things in the best interest of the children, according to Illinois law. So the legislature, in passing the Premarital Agreement Act, determined that it would not allow people to pre-decide or prejudge what would happen with children, because it wants the court to be the final adjudicator of those issues to protect the best interest of children in the state of Illinois. Importantly, you can change the terms of a premarital agreement in writing signed by both of you, and you can have a sunset clause stating that, for example, if you're married a certain amount of time, part or all of the agreement could be void at that point. Premarital agreements are enforceable in Illinois, and a divorce court will uphold those agreements. It doesn't mean that it's a shortcut to get your divorce done immediately. It just means that it will save you a tremendous amount of time and headaches in getting to a conclusion in your divorce case, because the financial issues and other issues set forth in your premarital agreement will be outcome determinative. A premarital agreement might be a useful tool to prevent litigation altogether, because the parties will know what the outcomes will be due to the enforceability of the premarital agreement. That doesn't mean that lawyers may not challenge the premarital agreement. Many attorneys attempt to challenge the validity of premarital agreements. And I will now discuss the weaknesses in premarital agreements that can be the basis for these challenges. So Illinois courts will hold premarital agreements invalid where the person challenging the agreement can show that the agreement was unconscionable when signed, meaning totally unfair when it was signed, and there was no proper disclosure of assets, liabilities, income, and expenses by the other party. And they signed no waiver document stating they waived the right to get access to that information. Also, Illinois divorce courts hold the power to modify spousal support provisions in premarital agreements that cause an undue hardship that was not foreseeable at the time the premarital agreement was signed. So an example would be if the parties were on a level playing field at the time the agreement was signed, and the recipient of maintenance suffered some terrible injury or disease during the marriage, rendering them incapable of paying any of their own expenses, the court would modify the support provision requiring the other party to pay some support to help pay for their expenses. Now, Illinois law and the statute states that the court is allowed to modify the support provision to the extent necessary to avoid undue hardship. So that leaves it within the discretion of the divorce trial court. That's all we have for today to talk about premarital agreements. As always, if you have questions or concerns, the best thing to do is reach out to us at STG Divorce Law by contacting us at stglawfirm.com. Reach out to us in the Contact Us box, schedule a consultation to speak with one of our experienced Illinois divorce lawyers. Follow us on social media. I'm at Raiford Palmer on Twitter, Raiford Palmer on LinkedIn, at Raiford Palmer on Instagram, and at Raiford Palmer on TikTok. Thank you very much for following. Please share and subscribe for more on Illinois divorce. Thank you.